Have you ever wondered who's legally on the hook if you get injured on someone else's property? You know, whether it's a slip in a supermarket or an accident in a park, there's a whole area of law that answers that exact question. It's called Occupiers Liability, and it's all about the duty that people in control of property owe to the people who come onto it. So, let's get into it and break down exactly how this works.
All right, here's our game plan. First, we're going to figure out who the key players are: the occupier, the visitor, and the trespasser. Then, we'll dive into the two crucial laws that run the show: the 1957 Act for lawful visitors and the 1984 Act for trespassers. We'll also look at how the rules get a bit different for special cases, like kids. And finally, we'll wrap up with the ways an occupier can defend themselves in court.
Okay, first things first. Before we can even talk about duties and who owes what to whom, we have to get the cast of characters straight. The law makes a really big deal about the difference between an occupier, a lawful visitor, and a trespasser, because the rules for each are totally different.
So who exactly is an occupier? Well, funnily enough, the law itself doesn't actually define it, so we have to look at the cases to see what the courts have said, and they've come up with a really clear test. It's not about who owns the place, it's all about who has control. An occupier is anyone with a sufficient degree of control over the property.
And this control test can be super flexible. Just look at these cases. The first one, Wheat v. Elecon & Co. Ltd., answers a key question. Can you have more than one occupier? Absolutely. In this case, both the brewery that owned a pub and the manager who ran it were found to be occupiers because they both had some control. The big takeaway is that control can be shared. Then you have Harris v. Birkenhead Corporation, which really pushes the idea of what control means. Here, a council had the legal right to take over a house, but they hadn't actually moved in or done anything physical. The court said, doesn't matter. The moment they had the legal right, they had control. So control can be purely legal. But then, check out Bailey v. Arms. It shows the flip side. A kid gets injured on a roof above a supermarket, and the court has to figure out who's responsible. The answer? Nobody. Turns out, neither the supermarket below nor the family living next door had enough control over that specific roof. So, no occupier. It's a simple formula. No control, no occupier.
So once we know who the occupier is, the next question is, who is on their land? You're either a visitor or a trespasser. A visitor has permission to be there. Either you were invited or the permission is implied, like when you walk into a shop. A trespasser, well, they don't have permission. And this difference is everything because it sends us down one of two completely separate legal paths.
Let's start with the path for lawful visitors. This whole area is governed by the Occupiers Liability Act of 1957. This law sets out one standard, universal duty that occupiers owe to pretty much everyone they've allowed onto their property. And this right here is the absolute heart of the 1957 Act. It's called the Common Duty of Care. Now, the wording is so important. The duty is to make the visitor reasonably safe, not to make the premises perfectly safe. That's a huge distinction. It means an occupier can have dangers on their property as long as they take reasonable steps to keep the visitors safe from that danger.
So what does reasonable actually look like? Well, the courts have made it clear this isn't about wrapping the world in bubble wrap. In Dean and Chapter of Rochester Cathedral v. DeBell, a guy tripped on a little lump of concrete. The court said, hey, tripping is an everyday risk of life. The cathedral wasn't liable for every minor imperfection. Then there's Laverton v. Capisha Takeaway Supreme. A customer slipped on a wet floor on a rainy night, but the takeaway had used slip-resistant tiles and had been mopping. The court said they did what was reasonable. The law doesn't expect occupiers to be superhuman and prevent every single accident.
And this is one of my favorite quotes in all of law, because it perfectly illustrates a key limit on the duty of care. The duty only applies for the purpose you were invited for. If a visitor goes off-piste, they wander into a staff-only area or start messing around with things, they might actually turn into a trespasser. And if that happens, the protection of the 1957 Act just vanishes.
Now, this common duty of care isn't just a one-size-fits-all thing. The 1977 Act is smart about it and actually requires occupiers to think about who their visitors are and adjust their level of care. So let's look at two complete opposites: children and highly skilled professionals.
Right, so the law gets that kids are, well, kids. They're going to be less careful. Occupiers have to be ready for that and guard against things that might attract a child's curiosity. The law has this great term for it, an allurement. Look at Glasgow Corporation v. Taylor. A 7-year-old died after eating poisonous berries in a park. The court said the council was liable because those bright red berries looked like candy to a kid. They were an allurement, and the council should have fenced them off. Foreseeability is also huge. In Jolly v. Sutton, 2 teenage boys got hurt trying to fix up an old abandoned boat. The court found the council liable. Why? Because it's completely foreseeable that kids would be drawn to an abandoned boat and mess with it. But there are limits. In Phipps v. Rochester Corporation, a 5-year-old fell into a trench on a work site. The council wasn't liable because the court said an occupier can reasonably expect parents to keep an eye on their really young kids.
Now, at the other end of the spectrum, you've got skilled visitors, like electricians or plumbers. The standard of care is way different here. An occupier can expect a professional to know the risks of their own job. The classic case for this is Rolls v. Nathan. 2 chimney sweeps died from carbon monoxide poisoning. The occupier wasn't liable because they had been warned about the fumes, a danger any competent sweep should have known about. But what if that professional messes up and hurts someone else? Well, the occupier might be off the hook, but only if they tick 3 boxes. 1. Was it reasonable to hire an expert in the first place? 2. Did they take care to hire a competent one? In Bottomley v. Todmorden Cricket Club, the club was liable for a fireworks accident because they hired amateurs without even checking if they had insurance. And 3. Did they check the work if it was possible? In Woodward v. the Mayor of Hastings, a school was liable when a kid slipped on an icy step left by a cleaner. That's a simple thing they could have and should have checked.
Okay, let's totally switch gears. We're leaving the visitor's path, and now we're on the one for trespassers. For the longest time, the law was pretty harsh. It offered almost zero protection to people on land without permission. But that view changed, big time, and it led to a whole new law, the Occupiers Liability Act of 1984.
This timeline really shows you how much things changed. It used to be brutal. In old cases like Addy v. Dumbrack, where a child was killed on some equipment, the rule was simple. Occupiers owed nothing to trespassers unless they intentionally hurt them. That all changed in 1972 with British Railboard v. Harrington. A 6-year-old boy was badly burned when he squeezed through a broken fence onto an electrified railway. The House of Lords said the old rule was inhumane and out of date. They created a new, limited duty of common humanity. This was a massive turning point. It basically recognized that a person's life is valuable, even if they're trespassing. And that's what led Parliament to create the 1984 Act.
So this is the law that now deals with trespassers, or as it calls them, persons other than visitors. There are 2 really important things to remember about it. First, unlike the 1957 Act, this one only covers personal injury, not damage to your stuff. And second, it completely replaced all the old rules.
Now, here's the absolute core of the 1984 Act. A duty to a trespasser is not automatic. It only kicks in if the answer to all 3 of these questions is yes. It's like a 3-part checklist. First, is the occupier aware of the danger? Second, do they know a trespasser might come near that danger? And third, is it a risk they should reasonably be expected to do something about? If you get a no on any of these, the duty doesn't exist.
Okay, so that's the test on paper, but let's see how it plays out in the real world by looking at how the courts have handled it in some really famous and important cases.
If you only remember one case for the 1984 Act, make it this one. Tomlinson v. Congleton Borough Council. A teenager, Mr. Tomlinson, saw a lake with big no swimming signs all around it. He ignored them, ran in, dived into the shallow water, and broke his neck. The House of Lords was crystal clear. The council was not liable. The danger wasn't the lake itself. It wasn't the state of the premises. The danger was what Mr. Tomlinson chose to do. The principle that came from this is fundamental. The law doesn't force an occupier to protect people from their own bad decisions, especially when the risk is obvious. It's all about personal responsibility.
And other cases really help us see how that 3-part test works. In Ratcliffe v. McConnell, a student jumped into the shallow end of a locked swimming pool at night. Just like in Tomlinson, the court said that's an obvious risk, so no liability. Then let's look at that second part of the test, knowing a trespasser might be there. In Donegue v. Folkestone Properties, a guy got hurt diving into a harbor in the middle of winter. The owner knew people swam there in the summer, but the court said they had no reason to expect anyone to be there on a cold winter night, so the second condition wasn't met. The first part of the test, being aware of the danger, failed in Rind v. Alstery Water Park. The owner had no idea there was a sharp container at the bottom of a lake, so how could they owe a duty for it? And finally, in Higgs v. Foster, a police officer fell into a pit while doing surveillance. The court said the occupier could never have foreseen he'd be there, so no duty was owed.
So, we've figured out when a duty is owed. But what happens if someone brings a claim? To finish up, let's look at how an occupier can defend themselves, either by showing they already did enough or by using a specific legal defense.
Under the 1957 Act for visitors, warnings are a big one.
But the law is specific. A warning only counts if it's enough to enable the visitor to be reasonably safe. A simple danger sign might not cut it for a really unusual hazard, like in Ray v. Mars, where a warning about a deep pit inside a pitch-black shed just wasn't enough. Of course, as we saw in Staples v. West Dorset, you don't need to warn people about an obvious danger, like a slippery, algae-covered wall. Occupiers can also try to use signs or contract terms to exclude their liability. But, and this is a huge but, the Unfair Contract Terms Act of 1977 says you can never, ever exclude your liability for causing death or personal injury through negligence.
For trespassers under the 1984 Act, the defenses look a little different. A clear warning sign can often be enough. In Westwood v. Post Office, a sign on a door saying only the authorized attendant is permitted to enter was considered a good enough warning for an adult employee who went in anyway. But the biggest and most powerful defense is based on consent. The fancy Latin term is volenti non fit injuria. It basically means no injury is done to a willing person. This just means the occupier owes no duty for risks that the trespasser willingly chose to take. This was the absolute core principle in both the Tomlinson and Ratcliffe cases, where the guys knew the risks and decided to go for it anyway.
Okay, so let's boil all of that down. The essentials are this. Occupiers' liability is split down the middle into two paths, the 1957 Act for visitors, the 1984 Act for trespassers. The key to being an occupier is control, not who has the deed. For visitors, the whole point is to keep them reasonably safe. For trespassers, a duty only even exists if that strict three-part test is met. And finally, a huge theme running through this, especially for trespassers, is personal responsibility for obvious risks.
And that really brings us to the big central question that this whole area of law is wrestling with. As we've seen, the courts and Parliament are constantly trying to strike a balance. But where do you think that line should be? How much should we protect people, and how much should we expect them to be responsible for themselves? It's a constant tug of war between safety and personal freedom.